Welcome to Lunchtime Law on the Margaret McLean Show. I'm a former prosecutor, civil trial attorney, and law professor. This is where we take the legal stories dominating the headlines and translate what's actually happening inside the courtroom. So please subscribe and press the like button. I'll be following all 4 of the civil cases which resulted from the criminal trial where Karen Reed was found not guilty of Boston police officer John O'Keefe's deaths. So you can find me right here every day, weekday at noon. So my thumbnail title for this show is based on a quote from Ellen Jackson, Behind Closed Doors, suggesting secret collusion between Special Prosecutor Robert Cosgrove and the Norfolk County DA's office. So Behind Closed Doors is also the title of one of my favorite thrillers I love to read. It's by B.A. Paris. It's a great summer read. You won't be able to put it down. If you haven't read it, go get it. Great beach read. So I'll get to the cell phone caper in a few minutes where the quote Behind Closed Doors came from. But first, let's talk about one of the Reed civil cases, and then we'll pivot. So they just had a status conference in the O'Keefe family lawsuit, wrongful death lawsuit against Karen Reed. And I'm going to put a little bit of a slideshow up here, not much of one, but here we go. Oops, not that one. There. So that's the civil suit with the O'Keefe family. That's Paul O'Keefe, where they sued Karen Reed for wrongful death. They've also sued the Waterfall Bar and Grill and C.F. McCarthy's. So they just had a status conference in the case. And, it was pretty civil. It was a short, routine conference. It was via Zoom, focused on coordinating the ongoing civil discovery and resolving lingering evidence sharing logistics between the parties. So the parties are currently trying to organize and execute dozens of depositions. So far, 12 are complete, with depositions scheduled, get this one, every day for the remainder of the discovery period. Attorneys for Karen Reed reported that 6 depositions have been completed, along with a portion of another. And what they're talking about there is Michael Proctor's, which they're not finished with, and they've got 9 more scheduled. So the lawyers representing the bars, the Waterfall Bar and Grill, they said they have 3 depositions scheduled, and C.F. McCarthy's have 4 depositions for late July and into August. Can you imagine the billable hours generated by all these depots? I mean, think about it, the prep, taking them, and then the review. It's pages and pages. I've handled thousands of depositions as a civil defense lawyer, and the time really adds up. So deponents have been scheduled to appear, and so far lawyers don't anticipate any attendance issues. Now, Judge Gilday said he believes he now has received all pending motions to compel witnesses to appear for depositions. He believes they all will appear, and there won't be any problem. So overall, the atmosphere was very cordial. I watched it, and the judge appeared satisfied, especially compared with the last time when he made the lawyers show up in person, including Ellen Jackson flying in from California, because he was upset over the leaks of sensitive impounded information regarding Proctor's medical records. So this case was continued to August 6th at 9:45 a.m., in which there will be another Zoom conference. But I do want to add one thing here, and that would be, I'm just changing my slide. So Colin Elbert. So we have a little bit of an issue there. Colin Elbert has not been deposed yet, and Reed's team is actively fighting to depose him, naturally so. They want to see if he really left 34 Fairview as early as he claims, and to discover any weaknesses that they can possibly exploit with his story. Here's the problem. Colin joined the Army and is in basic training at Fort Jackson. So his availability requires direct coordination with the Army Litigation Division. The defense wants a 3.5 window of his personal communications, while Colin's lawyer is arguing for narrowing the scope strictly to the dates surrounding John O'Keefe's death. I'll keep you posted on that one. You would think the Army would comply here, and because this is a deposition and it is a court subpoena. So we'll see what happens. So now we are going to shift gears, and I'll shift here. My next slide. Okay, well, that's Karen Reed and, of course, Aidan Carney. So we're going to shift to the battle over Karen Reed's cell phones. So it's entirely separate from the O'Keefe civil suit. Alan Jackson stormed into town this past Monday. He returned to his old stomping grounds, which is the Dedham Criminal Court, for an aggressive hearing over Karen Reed's seized cell phones. So why did they seize the cell phones? Well, state police seized them nearly 2.5 years ago. They took the phone through a search warrant during the separate criminal prosecution of Aidan Carney, better known as Turtle Boy. So prosecutors allege that Carney intimidated witnesses connected to the Reed case. Reed has acknowledged she communicated with him, and investigators believe her phone could contain evidence relevant to that investigation. So in February of 2026, a judge officially denied the special prosecutor's warrant to search or analyze the data on Reed's phones. Judge Beverly Cannoni previously ordered that the phone eventually be returned. So that's why Alan Jackson graced us with his presence. He says it's time for the government to give his clients property back. So far, the state has refused to return them. And why is that? So let me just show Jackson here. And they are looking at a phone, but it's not the phones that we're talking about here. The why? They say it's to prevent tampering or erasure of information. Now, Jackson argued that the original legal theory supporting the search warrant has largely run its course. Thus, there's no justification for continuing to hold Karen Reed's personal property. It kind of makes sense to me. But then Jackson took it a step further. He argued the problem isn't simply that the phone hasn't been returned, it's who's making that decision. He claims Special Prosecutor Robert Cosgrove is improperly working with the Norfolk County DA's office behind closed doors. That's the quote, behind closed doors. Special prosecutors are generally appointed to avoid actual conflicts or even the appearance of conflicts. So Cosgrove isn't supposed to be discussing these issues behind the doors, and it's not allowed and not a good look. Of course, Cosgrove denies it. So Jackson launched a motion to completely remove Cosgrove from the case. He argued that Cosgrove has a conflict of interest and is colluding behind the closed doors with Norfolk County DA Michael Morrissey's office to improperly withhold the phones. Basically, he's pointing out that the DA's office is still influencing decisions behind the scenes, which defeats the entire purpose of appointing a special prosecutor. Jackson also pointed to statements where he says Cosgrove previously made using the word we, basically meaning we, Cosgrove, and the DA's office when discussing decisions involving the phone. He told the judge he isn't holding the phone, they're holding the phone, meaning the DA's office. So this hearing also exposed something we rarely see so openly in court. Two accomplished lawyers essentially accusing each other of misrepresenting the facts. One side says the special prosecutor is working hand in hand with the Norfolk District Attorney's Office despite being appointed to operate independently. The other side says those accusations are simply false and baseless, and then turn the argument right back on Alan Jackson. So it's a battle between these two lawyers. So Cosgrove began by acknowledging that, hey, Jackson's presentation sounded compelling. Then he delivered what may have been the strongest line of the hearing when he said, "The only problem is those aren't the comments that I made." That's a direct challenge, right? So Cosgrove told Judge Doolin that his prior statements are preserved in court filings and on the record. He also filed an affidavit explaining what actually occurred. Most importantly, Cosgrove flatly denied coordinating with the Norfolk County District Attorney's Office. He made another interesting point. He argued that even if he were consulting with the DA's office, which he says he wasn't, he doesn't believe that doing so would necessarily create a legal problem because consultation alone isn't automatically prohibited. The legal question is whether another office is improperly influencing the independent judgment the special prosecutor is supposed to exercise. Well, here's my legal analysis. And by the way, ignore some of the noises in the background. That's my daughter making her lunch. But hey, I'm in my studio. So here's my legal analysis. What is Judge Doolin actually deciding here? Well, he's deciding several narrower legal questions. Is there still probable cause or another legal basis to retain the phones? So search warrants authorize the government to seize property for investigative purposes. They do not authorize the government to keep personal property forever. Once the government legitimately, sorry, I just saw my daughter, so she distracted me. Once the government's legitimate need ends, courts frequently order property return. I mean, that makes sense. That's the way it's always been when I was in the DA's office. So 2, is there an actual conflict here or merely the appearance of one? So Jackson's argument focuses heavily on appearances. Special prosecutors are often appointed precisely because public confidence in the justice system is crucial. If the judge concludes that the special prosecutor isn't acting independently here, that could affect decisions concerning Karen Reed. If he finds Cosgrove is exercising independent judgment, the conflict argument becomes much weaker. So it becomes a contest over what was actually said, who said it, and whether those statements accurately reflected what's happening behind closed doors. So Judge Doolin took the arguments under advisement on Monday and is expected to issue a formal decision soon on whether the special prosecutor will be disqualified and if Reed will finally get her property back. I have a feeling she will get those phones back. So on that note, it's Friday. Thanks for tuning in. And I'll see you Monday right here on Lunchtime Law with Margaret McLean. Thanks for watching.